Good afternoon, viewers, and welcome today to another interesting, insightful episode of Insights from Eximators Legal. My name is Esther, and today we will be talking about another crucial aspect of international investment law. This has to do with the fair and equitable treatment standard under the international investment law. This is a bit related to what we had discussed about 2 weeks ago when we were talking about expropriation, foreign investments by the host states. Today, we're discussing the fair and equitable treatment standard in relation to international investment law to open our eyes to how it helps investors in a foreign jurisdiction. What are the consequences of the fair and equitable treatment standard? And what are the elements that comprise the fair and equitable treatment standard? So basically, the fair and equitable treatment standard is a crucial element under international investment law. And it has actually become very indispensable now for international investment arbitration, because we discovered that in most investment treaties, the fair equitable treatment standard is actually one of the standards required by the host state to treat investors by. There are basically two direct consequences of the fair and equitable treatment standard. First, the investors. When we say investors now, we're talking about foreign nationals, foreign companies that come to invest in another country that is not their national juristic country where they actually citizens of. So a German company coming to Nigeria to come and investing in Nigeria, operating in Nigeria, is a foreign investor in Nigeria. So basically, the fair and equitable treatment standard has two direct consequences. First, the investors rely extensively on this standard when it comes to foreign investments, and also when there's a dispute and they have to go to arbitration in the investment arbitration courts, because it's sort of like a divine gift, in quotes, if I may use that word, for investors to use, which protects them from any harsh treatment, basically, by the host state. And that we had discussed before in our previous episode, the host state is actually the country where the foreign investment is being made. So the investors rely extensively on foreign fair and equitable treatment standards extensively for the foreign investment in the host state. And secondly, a lot of scholars, commentators, and even host states have started to violently criticize the standard, because of the unbalanced relationship, it allegedly creates between the foreign investor and the host state. However, this has actually been treated relatively on a case-by-case basis. But today, we just want to enlighten ourselves about what does this standard entail, why is it important, under international investment law. So basically, the fair and equitable treatment standard on a minimal level means the host state should not discriminate, whether by nationality or origin. So it should not discriminate the foreign investor, whether it be a company or an individual. It should not discriminate based on nationality or origin in respect of such matters as access to local courts, administrative institutions, applicable taxes, administration of government regulations. So, the fair and equitable treatment standard is actually, in a sense, to give the foreign investments and the foreign investor in the host state a leeway, in a sense, to be treated fairly. So, it as the name sounds, fair and equitable, treated fairly and in an equitable manner. So, if the arbitral tribunals finds that, okay, there has been an imbalance in the way the foreign investor has been treated, maybe there's been arbitrary taxes imposed, on that foreign investor, which is different from what is being imposed on similar companies in the same sector, then of course that's a breach of the fair and equitable treatment standard under international investment law. So basically, the fair and equitable treatment suggests that there should not be any discrimination by nationality or origin in respect of matters such as access to local courts, administrative institutions, applicable taxes, administration of government regulations. So the fact that a company is not only owned by Nigerians, for instance, should not deny the company from having access to our local courts here if it requires justice on a particular matter. It should not deny the company from having access to administrative institutions, government regulatory bodies here, and should be treated, fairly based on that fair and equitable treatment standard. So the fair and equitable treatment standard is provided for in a lot of bilateral investment treaties between host states, and is treated as a separate clause from what we call the national treatment and most-favoured-nation treatment requirements, which are different requirements under international investment law, but those are not the ones we're discussing today. So in order to show that there's a minimum international standard of behaviour applied to the treatment of foreign investments, as long as no discrimination can be shown. So the fair and equitable treatment standard is a separate clause under most bilateral investment treaties, and bilateral investment treaties are being signed between different countries, to allow for maybe their citizens, companies from different jurisdictions to be able to come into another country to operate their business. So most bilateral investment treaties and other multilateral treaties provide for the fair and equitable treatment of all foreign investments within each jurisdiction. So there's this particular case which actually explains, under international investment law, gives a good insight about what the fair and equitable treatment standard, is, or what's a violation of that fair and equitable treatment standard. And this case has to do with, it's called the Alexandrian Eastern Credit Limited case versus A.S. Balto, US, versus the Republic of Estonia. So it has to do with the company, Alexandrian and Baitol. They were operating in the country of the Republic of Estonia, and there was an allegation that the country, which is the host state in that case, violated the fair and equitable treatment by discriminating against the foreign investor in that case. And the arbitral tribunal actually found that acts violating the fair and equitable treatment standard would include acts showing a willful neglect of duty, an insufficiency of action falling far below international standards, or even subjective bad faith. So there's an international minimum standard created by the fair and equitable treatment under international investment law. And that if arbitral tribunals, investment tribunals now in most cases, if they find the host state guilty violating this standard, then it's a very serious matter under international investment law. That means that host state is in court, could be termed being hostile to foreign investments in their jurisdiction. So practically, discrimination against foreigners has been regarded as an important pointer of failure to grant fair and equitable treatment. So if you discriminate against foreigners, I'll use Nigeria now as a case study. So we have a lot of foreign investments in Nigeria. Being a developing country, a lot of companies come in, and it has actually helped the economy in a sense. But if there has been discrimination against some of these companies, foreign companies that come in, it's a violation of the fair and equitable treatment, and it could force these foreign investors to leave the country, which is actually not a good sign for the economic environment. So the fair and equitable treatment standard is described differently in various bilateral investment treaties. So the proper interpretation would be actually to say is influenced by the specific wording of each treaty. So Nigeria has bilateral investment treaties with different countries. We have the United States, we have the United Kingdom, that gives free trade between both countries. So it depends on the context and the wording of the fair and equitable treatment standard clause in each treaty. So there are bilateral investment treaties which regard the fair and equitable treatment principle alongside the rules of international law, while some others just provide that the fair and equitable treatment standard must not afford any lesser protection than what has been provided for under the rules of international law. So that's what is actually the minimum international standard afforded under international law. So arbitral tribunals have attempted actually to identify the various elements encompassed in the fair and equitable treatment standard, and we're going to point out these elements. And these elements are actually crucial under international investment law to identify what is actually a fair and equitable treatment standard, and if these elements are not present, can that be termed under the law as a breach of the fair and equitable treatment standard in a particular case. So the first fair and equitable treatment standard elements that have been identified by a couple of arbitral tribunals is one, transparency, stability, and the protection of the investor's legitimate expectations. So transparency, stability, and protection of the investor's legitimate expectations. Ideally, every investor has an expectation to operate in a friendly environment, in an environment that is not volatile to its business. So there's a minimum expectation, legitimately, that yes, we will be able to operate in a secure environment, we'll be able to operate in an environment that is not arbitrarily, the taxes are not going to weigh them down, and is able to make reasonable profit, while not exploiting the citizens of the whole state, with their businesses. There's an element of transparency in the fair and equitable treatment standard. There's an element of stability. So if there is any breach or a violation of that element of transparency, stability, or the investor's legitimate expectation, there's going to be established a violation of the fair and equitable treatment standard in such a case. Secondly, another element, that has been looked at and identified in a lot of arbitral tribunals, really, when it comes to what are the elements of the fair and equitable treatment standard and how can we categorize them. Second is the procedural, proprietary, and due process. Is there due process in what the foreign investments are doing, in what the host state is doing? The procedure that the host state is giving the foreign investor in, to go through, is it proper? That's the procedural, proprietary. Is it the due process that is being followed? Thirdly, complies with contractual obligations. So there has to be a proper compliance with contractual obligations. Good faith. Good faith is a key element actually in contract, under the contract law, the basic contract law. Is there good faith on the part of the host state, on the part of the foreign investor? And also, freedom from coercion and harassment, protection against arbitrariness and discrimination. So this has to do with the foreign investor, really. Don't forget, we had earlier said at the beginning of this discourse that the fair and equitable treatment standard majorly protects the investor. It protects the foreign investor. And so the foreign investor has to be able to know and identify that the host state is treating it free from all form of coercion and harassment, free from arbitrariness and discrimination. So the fair and equitable treatment standard is a very flexible, elastic standard, whose normative content is constantly expanded to include new elements. But these are the elements, the 5 elements we have mentioned earlier. They are the 5 basic elements that have been identified by a couple of arbitral tribunals over the years. Of course, the way the law evolves, and tomorrow something new could come up to add to the categorization of the elements that comprises the fair and equitable treatment standard. So they are not like closed-ended, as it were. So due to this flexibility, it has become the most often invoked treaty standard in investor-state arbitrations. So most of the time, when an investor takes the host state up on a violation, most arbitral tribunals, because most of investment cases, disputes, goes to arbitration, so that it doesn't waste a lot of time in litigation. So under international law, there's a lot of arbitration that goes on under the commercial arbitration, under investment arbitration, and things like that, to enable the cases to be properly decided within a particular time frame. So you find foreign investors taking the host state to court, and you find cases like maybe XYZ company versus United States of America. The United States of America, in that case, is the host state, and the XYZ company will be the foreign investor that is operating within the jurisdiction of the host state in that particular case. So most arbitral tribunals will, in most cases, find either a violation of the fair and equitable treatment, and most arbitral lawyers that defend foreign investors, that's one of the key things they first of all look at. Okay, has there been a violation of the fair and equitable treatment standard under the bilateral investment treaty or under the multilateral investment treaty, as the case may be? So it's really invoked most of the time by foreign investors. That standard is like the first that you can easily just invoke, when there's an investor-state dispute. So it's been used a lot of times. This standard has been used a lot of times as an alternative to provide protection to investors in cases where an indirect expropriation cannot be properly established or easily established. So if you cannot really say that, okay, the host state has expropriated the assets of the foreign investor, or is in breach, or try to take over the assets of the foreign investor, if you cannot really establish that easily, you can easily establish the fact that yes, there has been a violation by the host state of the fair and equitable treatment standard. So we are going to move on to identify a particular issue and really examine whether the fair and equitable treatment standard should vary according to the level of development, governance capacity, and resources of host countries. So, should we look at the peculiarity of each host state? The country now, when we say the host state, we're talking about the country where the investment is being made. So, should arbitral tribunals really look at the peculiarity of each host state in terms of what's their level of development, what's their governance capacity, what's the resources capacity of the host state in being able to identify whether the fair and equitable treatment standard has been breached or is being upheld? Well, in my view, and based on works I've done in this area in terms of articles I've written, researches that I've done, I believe that the fair and equitable treatment standard should actually vary according to the level of development of the host state. You cannot compare the level of development in third world countries in Africa to the level of development in more established jurisdiction, let's say like Germany. you have to look at the governance capacity, you have to look at the resources of the host state before you can really establish, okay, in this case, has there really been a violation of the fair and equitable treatment standard or no? So the fair and equitable treatment standard should actually vary in accordance to the level of development, the governance capacity, and the resources of the host countries, which are the host states, as we're discussing. So the peculiarities of the host state in which a foreign investor has come to invest ought to be considered in interpreting the fair and equitable treatment standard if there is a dispute, and also in establishing the violation of the fair and equitable treatment standard in cases of a dispute. So foreign investments in developing countries, for instance, is an implied acceptance by the investor of a potentially less stable social, economic, and political environment. So if somebody, for instance, goes to invest, a company, a foreign company, let's say a company from the US, goes to invest in a developing economy that is still coming up, that has a lot of volatility in terms of instability of the political terrain, their laws are still evolving in terms of the economy. So a developing country would not have an established terrain, because they might make a law today and they see that, okay, yeah, this law is not really auguring well, maybe with the economic terrain, and tomorrow maybe they change it, they pass another bill. It's not really like established like a developing nation. So a foreign investor that goes to a developing state to go and invest should definitely accept the potential of volatility in that environment, and that the socio-economic environment and the political environment in that state may not be necessarily stable. So if they make a law that affects that foreign investor, it might not necessarily be to violate the fair and equitable treatment standard. It might just be also for the host state to be able to protect its economic terrain. So during the arbitral tribunals, if there's a dispute, the arbitral tribunal has to look at, that's why they look at things in case-by-case basis. Okay, the way I will interpret as an arbitrator in an investment tribunal, investments in using developing nations, let me say, Myanmar, where now they have a lot of political instability. It will be different from how we will interpret the fair and equitable treatment standard in an established economy like the United Kingdom. Because their laws most of the time are relatively stable in the developed economies. So the threshold in which the fair and equitable treatment standard has to operate is determined by the general situation of the host state. And that is realistic. One has to be very realistic when dealing with these things, in the sense that the arbitral tribunal has to consider the treatment a reasonable state in similar condition offers to its foreign investors. Of course, we're not saying if the host state imposes very discriminatory, arbitrary taxes on foreign investors, of course, that is clearly going to be a violation of the fair and equitable treatment standard. However, the arbitral tribunal has to also look at, okay, what's a reasonable state in similar condition, in similar economic condition, like the current state before it? What kind of measures are they putting in place that will be able to give the arbitral tribunal the assessment to know, okay, whether there has been a violation or no of the fair and equitable treatment standard. So the standard of treatment offered by the host state is basically influenced by issues such as the level of development, the government's capacity, and its resources be it natural or economic, as the case may be. There's an interesting case I would like to point out, and to be able to reiterate and buttress this this point. There was a case about LG&E against the country of Argentina. LG&E had invested, as a foreign investor. They were operating in Argentina, and something had happened, and they actually claimed that the government of Argentina had violated the fair and equitable treatment standard, under international investment law, maybe by some of the policies, the rules, and the laws that they brought in, eventually, that sort of distorted the foreign investors' business. And they expressed, that the tribunal actually said something which buttresses the fact that tribunals under international investment law, they look at the peculiarity of each state. They said they recognize the economic hardship that occurred during that period in Argentina, and certain political and social realities that at that time may have influenced the government's response to the growing economic difficulties. And don't forget, every state wants to protect its economic terrain. They want to protect their citizens. They want to protect their rules. They want to make sure that, at least to a large extent, they put in measures that will reduce the economic hardship within their environment. So at times they may have to make certain decisions that in the interim or temporarily could affect foreign investment or even local investments, in the interim, so that there will be stability eventually in their economy. So the tribunal in this particular case of LG and E against Argentina, they actually recognize that, well, during the period when maybe Argentina did certain things, they recognized that there was economic hardship, and that influenced, what the government of Argentina had to do to be able to save the situation in their country at that time, which unfortunately affected, a foreign investor. So this buttresses the notion that the specific investment and regulatory environment of the host state must be considered when determining the fair and equitable treatment standard. Also, there's this case, the thing about international investment law when it comes to investment disputes is that we look at a lot of investment dispute cases and what arbitral tribunals have actually decided. So most of the time, the decision of arbitral tribunals, in a lot of cases, forms the basis of the law eventually for most standards, or how the arbitral tribunals have interpreted multilateral investment treaties or bilateral investment treaties on a case-by-case basis. So there's this case, in Estonia. There's this company, foreign investor as well, it's called Genin at that time. They alleged the revocation of their banking license, saying that the Republic of Estonia violated the fair and equitable treatment standard when they revoked their banking license, and that under the bilateral investment treaty between the United States and Estonia, because Genin, in this case, is a U.S. company, is a company owned by Americans, and they were operating in the Republic of Estonia, at that time. So they're saying that revocation of their banking license in Estonia is a violation of the fair and equitable treatment standard under the bilateral investment treaty between the United States and the Republic of Estonia. But the ICSID tribunal, is the investments, the tribunal, that looks at investment disputes under international investment law. They accepted the explanation of the host state in this case, to the effect that the circumstances of political and economic transition prevailing in Estonia at that time justified heightened scrutiny of the banking sector. So, quoting the tribunal, it says the tribunal considers it imperative to recall the particular context in which the dispute arose, namely that of a renascent independent state, coming rapidly to grips with the reality of modern financial, commercial, and banking practices and the emergence of state institutions responsible for overseeing and regulating areas of activity perhaps previously unknown. So this is just quote and unquote, what the tribunal actually said. And a state, being a jurisdiction, an independent sovereign state, has to protect its economic environment, its political environment, regardless of the foreign investment there. So when we look at these cases, yes, the investors are protected by the Fair and Equitable Treatment Standard. However, it's still in relation to what obtains within their host state. Does the environment or the situation of the host state gives room for the government to take certain actions? And if they have to take those actions, if it affects the host state, will they be liable in breach of the Fair and Equitable Treatment Standard or not? So some of the elements of the Fair and Equitable Treatment Standard, as we have mentioned, such as protection against arbitrariness, discrimination, good faith, due process, identified by arbitral tribunals, are actually rooted, in international law. So investors, they usually claim that the Fair and Equitable Treatment Standard does not constitute a part of the international minimum standard, but that it's an independent standard of international law against which the behaviour of the state has to be measured. Well, the Fair and Equitable Treatment Standard is actually part of the international minimum standard under international investment law. But investors, like every other person, will want to argue their cases to favour them, as it were. But there are times that the host states have to take certain decisions. However, there has to be a balance, as long as those elements that we reiterated earlier about transparency, stability, not discriminating, no arbitrariness, can be found in the way the host state treated the foreign investor. Then there will be said that there was no violation. So we've spoken a lot, today, within the time that we have, about the Fair and Equitable Treatment Standard. What is it? What are the elements? We've mentioned and explained some of the cases, in reality, have been decided, on some investment disputes, and what the tribunals have found, whether there have been a violation or not of the Fair and Equitable Treatment Standard. So the international law is the root of the Fair and Equitable Treatment Standard. We need to make that clear. And no matter how one wants to view it, really, it cannot be totally independent of the minimum standard treatment under international law, provided for under the customary international law. So it's part of the international minimum standard. It's just the base that, okay, there's a base that, okay, have they been fairly treated? Has the foreign investor been fairly treated? Have they been treated equitably by the host state? So even though the Fair and Equitable, clearly the Fair and Equitable treatment, as we have mentioned, is one of the most promising standard of protection from the perspective of the investor. So any foreign investor going into any host state to go and establish his business, if there is any dispute, that is the first standard. That's the first clause in the bilateral investment treaty that they are hinging on between their own country and the host state, that they want to establish and say, yes, there's been a violation or not. And that's part of what the initial stage that the arbitral tribunals, the investment arbitral tribunals will look at. So even though the Fair and Equitable Treatment Standard should vary according to the level of development, as I've established earlier, even though it should vary according to the governance capacity, even though it should vary according to the resources of the host state, due to the fact that countries are at varying levels of development. And what is fair and equitable is quite relative to their socio-economic and political circumstances. There is, however, there's a caveat here, however, a place for recognizing the minimum standard of treatment under international law, regardless of the level of development of that host state. There's still supposed, what is fair for the foreign investor. And there should be a minimum standard of treatment. So because foreign investment is more under the auspices of international law and is regulated as such via bilateral investment treaties between the foreign investor and the host state. So the minimum international standard treatment, also regulates that fair and equitable treatment standard. So even if the country is a developing country, is a war-torn country, yes, the government has to make some adjustments which could affect the foreign investment in that host state. The host state government too must make sure that they are not in violation at least of the minimum international standard of protection of the foreign investment in their jurisdiction. So there is no doubt, in conclusion, that the fair and equitable treatment standard is meant as a rule of international law and is not determined by the laws of the host state. So is a rule of international law. Fair and equitable treatment standard clauses are found in investment treaties between countries. So it's obvious that some states, especially developing countries, have entered into a lot of bilateral investment treaties without proper consideration or understanding of the resulting consequences, whether negative or positive. And the aim of this discourse really, is actually to open our eyes and also to point out that it's not just enough to copy investment treaties from developed nations. No. Developing countries have to consider, when treaties are being signed, what is in their own treaty relative to what operates in their own jurisdiction. So it's not just enough to just say, okay, yeah, let's just have any bilateral investment treaty between Nigeria and America. The level of development in Nigeria is far different from the level of development in America. So when signing or entering into bilateral investment treaties, all states also has to be very careful to have a proper understanding of the consequences against them, whether negative or positive. So today, we've been able, I believe, we've been able to enlighten ourselves on the fair and equitable treatment standard under international investment law, and being able to also caution foreign investors and the host states, when parties are coming together to operate the business in a separate jurisdiction that is not theirs. So thank you so much for listening today. Thank you for joining us today. And we hope to bring you another interesting concept under international law, under international commercial law in our next episode. Thank you, and God bless.